He is paying monthly. So we've collected almost over $300,000 just this year.
What's the total amount that he owes?
That is remaining is about $450,000.
This is up for an arrears payment. He's not here. They were asking for $6,000 a month.
Well, he asked for a continuance, and Mother is also asking for a continuance to be represented. Father is actually the one that requested the $6,000 a month payment because we have an administrative charging him a lot more than that.
Oh, really?
Yes.
Well, from what I saw about his income from this file, it looked like whatever number you pick is probably just fine.
Yes.
Especially as much as he owes. Yes, ma'am.
I would like a continuance, but I'd like to explain why.
I actually don't need an explanation. If you're both agreeing that it should be continued, and they'll leave the current administrative amount that they're collecting in place.
Well, the question that I would like to ask is, does the court have the authority to request a writ? Because the original order of the court from Santa Clara County was for him to pay arrears through the sale of his investments, not through his salary. And because he was ordered to pay child support arrears back in 2021, and he neglected to do that. And so the court's orders were specifically to sell his investments to pay those arrears. And the issue that we're having, and why I'm trying to file the continuance, is because I have not received court-ordered alimony because child support services is garnishing half of his paycheck already. So it's blocking my ability to receive court-ordered alimony.
Well, then I can't imagine that they're getting anything for arrears, because they would pay ongoing child support first, ongoing spousal support second, and any arrears third.
So the children are emancipated, and so we are actually not.
Well, you're not enforcing anything for spousal.
Exactly.
Right. And
the hearing centered on massive child support arrears exceeding $450,000, while both parties requested a continuance and debated how the outstanding obligations should finally be enforced.
He's using the legal loopholes to, again, evade paying.
Well, so your problem isn't so much the need, well, you might need a writ for yourself.
Right. Which
I would not be in a position to order because I only deal with child support, just like DCSS.
But my question is, can you order a writ for all of the arrears to be paid as the original order was written?
For the child support?
For the child support
arrears. Sure, and normally the way that happens is, and you can talk to DCSS about it if you haven't already, they're the enforcers, and they're the ones who would normally ask for the writ and go out and go after his investments.
I've requested that, and they say that they are not able to do that, and they haven't explained why.
He is paying monthly. So we've collected almost over $300,000 just this year.
What's the total amount that he owes?
That is remaining is about $450,000.
In child support arrears?
In child support arrears only, yes.
Only. And I'm not able to receive any spousal support, and I have not received any because Child Support Services has a lien on only his bank account, not his investments, which was what the original order was. And now I'm going to have to pay more attorney fees to request an attorney to file a writ, and it would be a lot easier for you to do it.
No, I wouldn't. And actually, and I'm remembering back to my days in private practice, when I would issue a writ, it identifies how much the arrears are, and it identifies how much interest is accruing on the arrears. And it's issued just a matter of course by the clerk if they verify the support order. And then it goes back to you to give to the sheriff's department to go serve the writ on wherever he has his investments. And then he has the opportunity to seek to put a stop on that, but then it comes to court. That's the first time that a bench officer actually looks at that. But that requires you or somebody on your behalf, like a lawyer,
Right.
to prepare the written.
The mother argued earlier court orders required the father to satisfy support debt by selling investments, claiming wage garnishments prevented her from receiving court-ordered spousal support despite years of litigation.
Didn't submit it to the clerk's office.
I can't do it because Child Support Services is taking over jurisdiction.
Not on the spousal support. Are you saying that what you want is a writ on his assets to satisfy child support? Why don't you just go get a writ to collect on the spousal?
Because the way in which the court order was written was that child support arrears get paid first, and also alimony get paid, and then spousal support arrears gets paid last. So I suppose I could file a writ for spousal support, but I've already spent, Your Honor, over $1 million in legal fees. My ex-husband liquidated all of our assets prior to leaving the marriage. So he left the children and I with nothing. And I've raised the children until they left to high school. So I'm in constant litigation because of this man. And he is utilizing the legal system to his benefit. And I'm, at this point, I'm hoping, I really don't want to incur more and more attorney fees. And I'm hoping that the court could help Child Support Services, which they have helped me, but I need the only way to get him to pay what he owes is to do what the court originally ordered, which was, and I can even read the order that the judge wrote to you.
Well, but I'm going to stop you there. That means it's already in order. So what I'm hearing you tell me or ask me to do is to confirm the order, to order that DCSS enforce the order. They should be enforcing the order already. So if there's an order out there for them to go after his assets, then that's what they should be doing. Even if they're getting money from other sources, they routinely will still go look at bank accounts. They will intercept tax refunds. They do other things. They go to brokerage accounts.
They haven't gone to the brokerage accounts because
they have the ability to do that.
Okay, well, I'm okay.
If there's already an order for them to use those assets.
The commissioner explained that enforcement through writs normally begins outside the courtroom, encouraging the mother to work directly with child support authorities responsible for pursuing assets and collecting arrears.
And if they're doing it, then talk to their ombudsperson, and if necessary, ask for a state hearing so that you can talk to the powers that be on the state level. Why is the local agency not enforcing this court order?
Okay, because I just don't. I mean, it just keeps going on, and I just need the arrears paid so I can start receiving alimony, and start my life.
Well, the one thing I hear is that if they've already collected $300,000 this year, then pretty much by the end of the year they're going to be caught up on child support arrears.
No, I've already asked.
So the $300,000 that paid something else. So he had about $800,000 of arrears.
What did the $300,000 pay?
It brought it down from $760,000 down to $450,000. He just owes that much arrears.
That's how much.
But if you got that much, you've got that amount in 6 months. You've reduced it that amount in 6 months.
Yes.
But
So
I
in
owe
another 6
200.
months, it's going to be another $300,000 that'll be off, leaving less than $200,000.
We're not pulling that much monthly.
Oh.
So these were intercepts from bank accounts and other things. So we're
Oh, so
trying.
you are doing other things.
Yes.
Oh, just not the investment accounts.
I don't know if they came from investments accounts. I can't tell from just it telling me a withholding.
Can you hold one moment? I just want to make sure that my kids can't hear because I think my son just came home. Can you hold for one moment, please? I'm going to mute it.
Okay.
I'm going to move upstairs. Okay, can you hear me?
I can't.
You can?
Yes.
Okay, so yes, so that's the issue, is that child support services is,
Although officials reported collecting hundreds of thousands of dollars during the year, the mother insisted significant balances remained, arguing enforcement efforts had ignored investment accounts specifically identified in previous court orders.
are saying their hands are tied. The order is for him to sell all available assets. And the judge was very, very severe about it. Yet she put no guardrails.
Right.
Even though he is delayed paying for 8 years, has put me through 8 years of, I've been to court like 50 times. And he took everything. So the money that I received this year, which was a lot, but I had $250,000 of credit card debt and loans just to defend myself. So that's why I don't want any orders changed.
Was there no order for attorney's fees?
So he's ordered to pay attorney's fees on top of all this, and he's ordered to pay $169,000 of my attorney fees, but the most recent fees. But now I'm going to have to incur even more attorney fees just to enforce the order that's already been ordered.
Yeah, because DCSS won't collect attorney's fees or spousal support arrears.
Right. And then on top of that, he's changed his name. He's had plastic surgery. He's now moved to a different job, and he's a C-level executive. So all of his income is mainly stock, RSUs, LTI, and I didn't know any of this until I've had to learn about it, because I mean, I knew nothing about this. And so I have been at the will of the system, and I'm super grateful for child support services. But if they can't file a writ of execution on his investments, and that means all of them, and that includes all the ones that he's hidden, because I do know my son went to Ireland for the fall. He's not even supposed to pay for anything until he pays the arrears. And he's gotten my kids apartments in New York and Boston. He's paid for cars. He has a Rivian that he never declared. He bought a $2 million condo. The guy is, and no one is enforcing anything, except for child support services. But it's not enough for me to start moving forward with my life.
And all I can do is wish you good luck. And
She described years of exhausting legal battles, mounting attorney fees, hidden assets, and repeated attempts to enforce judgments, believing every delay allowed the father to further shield his growing wealth.
hope that DCSS can do more than they've been doing. With the order that you say is in place, it seems to me they have the ability to do that, but there's nothing more that I can do. I mean, the best that I could do is order that he comply with the order, which makes no sense.
Okay, so I guess this hearing is delayed.
Well, apparently everybody's asking to delay it. So, but it ought to be interesting when he finally shows up, because I'm going to need to see an income and expense declaration before I'm going to do anything.
Well, sir, I'm going to have to subpoena all his bank account records again, because he's lied on every single income and expense declaration, and I have proof. Every single one.
Do we have an anticipated date or a
We
proposed
do
date?
not have an anticipated date. It will be up to Ms.
To
Beckford.
the boss.
Yeah, the availability of the calendar.
I just need enough time to get my attorney up to speed, and I only have so much money because I had to take a loan out again, even though I was finally able to pay off my debt. But I now have had to take out a loan because every single person I've talked to has said, you have to have an attorney. This is the most complex situation, and
I don't disagree with that. Does he live in Sacramento?
He used to live in Las Vegas, and I know that he now has a job with Caris Life Sciences. He probably got a large termination package from his old company, and then the Caris is based in Texas, from what I understand from my children, he's moved to Phoenix, Arizona, but I have not. I've emailed him multiple times to start paying me alimony. He has ignored all my emails. I've tried to reach to his brother and his mom. They've ignored me. Like, I have no way of reaching him. So now I have to hire a private investigator. You know, it's just this guy. I don't know how the system allows this.
Well, we're limited on what we can do. Somebody has to bring something to us.
The commissioner acknowledged her frustration, but emphasized the court's limited authority without proper motions, financial disclosures, or the father's appearance, ultimately granting additional time for legal preparation.
And he has to be notified of the request, that he has the opportunity to be here. Joseph,
I can't serve him if I don't know where he lives.
Well, DCSS apparently does. Is August 26th far enough out?
If we could do 60 days, I would be grateful for that.
Okay, that's fine. That's easy. Sure, September 29th.
Thank you. I really appreciate you listening to me.
Oh, the 30th? Okay. We'll
30?
keep it on the same calendar.
I have to get my attorney, like I need to find an attorney and see if that date is okay with them, but
If it's not, let DCSS know and they can work with us to get a different date.
okay.
Does put it out far enough though so that it gives us wiggle room. Okay.
In terms of the payments though, with DCSS, I because I'm not receiving any spousal support at all, and the spousal support I'm supposed to receive is $13,600 a month, and he is just not paid anything. So I'm working my tail off to try to keep, a house over my head.
I know it's not anything makes you feel any better, but the missed payments are accruing interest at 10% per year.
Well, okay, yeah.
Yeah. No, I get it.
The 10%.
Your Honor, I don't know if this will help her. If we reduce his arrears payments to $6,000, that would free up the 50% of his payments to pay her the $13,000. We're essentially pulling about $17,000 out of his income monthly. So she would be in the same position with.
But isn't all of this money going to her anyway?
Yes, it's
so
all
does it
owed to
matter
her.
whether it's child or spousal support?
Yeah, and I have to go to trial and law, and for me to file a writ on my own, that's going to take a good few more months. So I don't want to change the order of the court. That's the most important thing.
I get that.
Okay, but I do want child support services to be able to get as much money they can, because I'm not receiving anything at this point, and I need to be able to pay my bills.
Other than what they're getting in child support arrears now.
Right. And
which she's saying is $17,000 a month.
Next voice. Attention turned toward ongoing support payments, intercepted severance funds, and complicated collection procedures, revealing how overlapping child support and spousal support obligations created continuing financial uncertainty for both enforcement agencies and the mother.
No, I'm not getting $17,000 a month. I got $1,000 last month, and I got $4,000 this month.
Not sure why.
Because
your office received more than that?
Our office has received more than that. So
they've been going on vacations over there at DCSS.
So we haven't got anything this month. Last month we got about $6,000, so she should have received more than $1,000. And if it's coming out piece by piece, maybe that's why she's only getting a certain amount at a certain time.
But cumulatively over the last month and a half, she hasn't got $17,000.
No, I got $1,000 in the month of June, and I got, I think.
And so he did switch employers within the last couple of months. So it does look like we intercepted his severance package, which was almost $200,000. And then the 1 to 8 months before that, there were $14,000, $17,000.
When did you get the $200,000?
That was in April.
Ah, okay. So you got that?
That helped me pay my debt off.
Yeah, good. Okay,
But now I have more debt because I have to hire an attorney.
I understand.
I think, he should go to jail. It's been 8 years of just constant,
Yeah, but I mean, if they're collecting as much as they seem to be, I think you'd rather have them out there having money to collect rather than in jail.
I don't know. All I know is that I know he has assets overseas and he's moving. He's now had a lot of years to move his assets. And I know he has a bank account of Ireland for sure, because that's on it. That's on one of his paychecks. So,
And Ireland doesn't accept writs from the United States.
they don't, but the court, if they can find that he's moving his money overseas, such as Firebank, which is another bank he uses overseas. He is completely laundering money. He is completely unlawful. He's in contempt of court. He's lied on all of his income and expense declarations. He's purchased a $2 million.
The mother alleged the father concealed assets, changed employers, relocated across multiple states, maintained overseas financial accounts, and repeatedly filed inaccurate financial disclosures while continuing an affluent lifestyle despite unpaid obligations.
Condo while owing support arrears. He's purchased multiple cars, Land Rover, Rivian, a Lariat truck. The man is so elusive, and I have all of the proof. So now I have to get an attorney that's going to be very, very expensive, because only attorneys that have this kind of understanding of C-level executive income and them hiding assets is someone who is going to cost a lot of money.
Sure, because they're experts.
Right.
So have you thought about going to the FBI?
I have. I've already gone to the FBI, and they said this is a family court issue. I've gone to the police department, and they said, well, this is a family court issue.
That's interesting, because there are code sections that make it a felony or a misdemeanor to not pay support. So why would we have something in the penal code if it's not enforceable?
Well, the FBI has told me that you can't go, that I have to deal with the family court. And then the police, I've gone to the Los Altos Police Department, I've gone to the Menlo Park Police Department, I've gone to, and on top of this, Child Services, he was abusive. So Child Services never ever filed a report until all of our trials were over, and the judge said she didn't know that there was any abuse, and there's massive documents of abuse. So I've been...
Okay, I gotta call a halt to this proceeding. I don't think there's anything more that I can do today. Good luck. That's about all that I can offer you.
The hearing concluded without substantive relief for the mother. The commissioner continued the matter approximately 60 days, to September 30th, to give the mother time to retain an attorney and to allow DCSS to prepare. The commissioner acknowledged the severity of the situation, but was candid about the limitations of the court's ability to act at this particular hearing. Nobody was requesting an order today. The father had not appeared, and there was no income and expense declaration before the court to evaluate. The commissioner's final words, "Good luck, that's about all I can offer you," were delivered not with indifference, but with the resignation of a judicial officer who recognizes the structural failures in a system that allows a high-income obligor to accumulate nearly $1 million in combined arrears while purchasing.
Unable to provide immediate relief, the commissioner postponed the matter for approximately 60 days, advising the mother to retain experienced legal counsel while child support officials continued their collection efforts.
Luxury vehicles and real estate. This case exposes a fundamental inequity in family law enforcement that disproportionately affects custodial parents, particularly mothers, who lack the financial resources to pursue well-funded obligors through the legal system. The mother has spent over $1 million in attorney fees. She accumulated $250,000 in credit card debt defending herself. She paid that debt off with the intercepted severance payment, only to immediately take out new loans to hire yet another attorney. Meanwhile, the father, a C-suite executive whose compensation is structured through stock grants, RSUs, and long-term incentives designed to be difficult to garnish, has purchased a $2 million home, bought luxury vehicles, funded his children's international education, changed his name and appearance, relocated across state lines, and maintained overseas bank accounts. He has lied on every income and expense declaration, according to the mother's testimony. He has ignored emails requesting spousal support payments. And he has not appeared in court today. The system as it currently operates requires the person owed money to spend money. They do not have to collect money they are legally entitled to from a person who has structured their entire financial life to avoid paying it. DCSS has statutory authority to pursue investment accounts, but the mother testified they told her their hands were tied. The FBI said it was a family court issue. Local law enforcement said the same. The penal code criminalizes willful non-payment, but no agency will prosecute. The court cannot issue orders when the obligor does not appear and no motion is properly before the bench. And so the mother, who raised the children, who has been the custodial parent, who has court orders in her favor totaling hundreds of thousands of dollars, leaves the hearing with a continuance date, a suggestion to contact the DCSS ombudsman, and the commissioner's well wishes. There is a word for what this father has done over 8 years. It is not merely non-payment. It is financial abuse conducted through the legal system itself. When a person with the resources to pay uses name changes, plastic surgery, overseas accounts, employer transitions, and serial non-appearance to avoid court-ordered obligations while simultaneously purchasing luxury assets and funding an affluent lifestyle, they are not struggling to pay. They are choosing not to pay and daring the system to stop them. The system, so far, has not. The mother's closing words, "He should go to jail," reflect a frustration that millions of custodial parents share. Whether the system will eventually hold this father accountable with consequences proportional to his conduct remains to be seen. Based on the last 8 years, the mother has every reason to doubt it. Let us know if there is a case or legal topic you'd like us to cover next.
The hearing ended without new enforcement orders, illustrating the immense challenges surrounding high-value support cases where complex finances, prolonged litigation, and procedural limits can delay accountability despite substantial outstanding court-ordered obligations.